Today, the Supreme Court ruled that juries in state criminal trials must be unanimous to convict a defendant. Up until today, divided votes in Louisiana and Oregon sent suspects to prison.
Yeah, this is a big deal. Justice Neil Gorsuch called that practice inconsistent with the Constitution's right to a jury trial. He also said that it should be discarded as a vestige of Jim Crow laws in the state of Louisiana. And joining us now tonight to talk about it, the attorney who led the fight for unanimous juries in Louisiana. He is attorney Ed Tarpley. And attorney, welcome first off, and what was your immediate reaction to today's ruling, and what does it mean?
Well, we were just ecstatic with the ruling. Frankly, it was anticipated. I was at the oral argument in October, and I could tell by the questions from the justices back then that it looked like we had six votes in favor of declaring the Louisiana and Oregon law unconstitutional. And I was anticipating the decision. So when it came down, though, it's just a tremendous victory for the cause of liberty everywhere, and especially for those of us in Louisiana who have fought so hard to get rid of this law in Louisiana. So it's just been a great victory for all of us.
So for most of the country, maybe a lot of us didn't even know that laws like this still existed. When did these laws start to disappear?
Well, let me just say that the right to a trial by jury has always included the fact that the verdict must be unanimous, that in order for a person to be convicted of a felony, all 12 jurors must agree. And this has been the law in 48 states in the Union. Only Louisiana and Oregon ever had a law which allowed a person to be convicted with a non-unanimous vote of the jury. The law in Louisiana goes all the way back to the post-Reconstruction era. The Louisiana legislature in 1880 passed legislation which allowed juries to convict someone with a less than unanimous verdict. And then in 1898, it was placed in the state constitution, which is where it remained until 2018, when the citizens voted to restore the unanimous jury verdict to Louisiana. In Oregon, their law goes back to the 1930s. And so only Oregon and Louisiana ever had non-unanimous jury verdicts. But thankfully, after today, neither Louisiana or Oregon has a non-unanimous jury verdict law. So we are really, really grateful and excited about what happened today.
Well, Attorney Tarpley, thank you so much for fighting the good fight over there in Grant Parish and Alexandria, Louisiana. We give our best to all the folks over there, and thank you so much for joining us.
Thank you. Thank you. Well, let me just say, it's been a great day, for the cause of liberty and justice. We've had people that have been fighting this for a long, long time. And, I'll have to say this. One of the things that I pointed out, that the citizens of Louisiana voted by 64% of the vote in 2018 to pass Amendment Number 2, which brought unanimous juries back to Louisiana. But it was prospective only. It was from January 1, 2019 and forward. So anybody that was charged with a crime committed prior to January 1 of 2019, they were still under the old law, which allowed them to be convicted with a less than unanimous jury verdict. So what the Supreme Court did today is they decided once and for all that the Sixth Amendment requires a unanimous jury verdict. And that's going to be true in Louisiana and in Oregon and throughout the nation. So this is a tremendous victory for the whole nation. But you just need to be reminded that only Louisiana and Oregon had to deal with this. All the rest of the 48 states never had non-unanimous jury verdicts. But the Supreme Court has decided today, once and for all, that the Sixth Amendment requires unanimity, that all 12 jurors must agree in order for a person to be convicted of a felony offense.
All right. Good job out of you and your crew, sir. Thank you so much again for joining us.
Yeah, thank you for having me on.
You're welcome.